No. Hold on. Okay, we're officially live. So welcome everybody. I'm excited to talk through some estate planning mistakes, and I'm joined by Betsey Rubel. Welcome, Betsey.
Thank you.
It's been a while since we've done a online webinar. We've been enjoying going back to in person, but thought that this would be a nice way to quickly get some important content out. We're going into summer vacations. I know we often, Betsey, I'm sure you do, get some calls right before people are jumping on flights and all that of, hey, I want to make sure this is all in place. But this is always a timely topic, but today we're just going to focus on some mistakes that we see people make, and thought this would be a good way to just dive into a topic that nobody really likes to talk about, but it's super important, super important. So with that said, let me go over a couple of housekeeping items. If you want, we want this to be interactive. If you guys have questions on the fly or something comes up, you can just use this Q&A and click on that on your Zoom functionality, however you're using it. Click Q&A, throw that question in there. If it's appropriate and we can field it right, on the fly, we'll do that. If not, we'll get an answer back to you. If it's not more of a general question that would apply to everybody, we'll make sure we address that. And then other than that, we are going to kind of jump in and start getting into some estate planning mistakes. So before we do that, I'm Brandon Kennedy, president of Kennedy Financial Group, joined today by Betsey Rubel. Betsey, you want to give us a little bit of an introduction to who you are, what you do,
Sure.
and all that good stuff?
Yeah, absolutely. So hi, everybody. I'm Betsey. I'm an estate planning attorney. I've been practicing in this area for about 20 years. I'm a solo practitioner. It's just me at my practice. I'm from Holland, Michigan, on the west side of the state. I went to law school at Wayne State. I love what I do. I feel like this is an area that, as Brandon alluded to, a lot of people don't want to talk about it, put it off. It just seems like something that everybody knows it's important, but it often kind of sneaks down on your to-do list. So, the biggest satisfaction I get from my job is helping folks who, you really didn't want to go into this process, but you really feel good about having that peace of mind of having all the proper documents in place. So it is really important, and that's why I really do enjoy what I do. Probably 80% of my practice is estate planning, which means wills, trusts, power of attorneys, patient advocates, and then the balance is probate and trust administration. So I kind of see the other end of it as well, where maybe you're in probate court because something went wrong. So it's good to have that knowledge to kind of use that to make sure that the plan is in place from the beginning, so you don't run into issues when you're administering an estate. So so that's a little bit about me. I've known Brandon for a long time and have helped a lot of his clients. So we're excited to kind of give you some information and talk about some mistakes that I've seen over the course of my practice, and kind of go from there.
Perfect. No, I think that's, why it maybe a good tie into what we're trying to help you avoid our mistakes. But the hope today is maybe you pick up one or two items that maybe for your existing plan, you can go back and revisit, or you completely overlooked. Sometimes it's a technical understanding. We're going to get into both of those things that are overlooked or maybe misunderstood. And then certainly if this doesn't apply to you, I'm sure you know somebody who either you think, hey, maybe you should take a second look at this, or this is worth resharing. This is recorded. You're going to get a replay of this. And this is really helpful information. It's not a sales pitch to get an estate plan done by Betsey, although she does a great job, but really just educational in nature. And that's really our hope, is that you gain something from this or can help somebody else. So with that said, let's jump right into kind of a first mistake that we want to talk through a little bit. And that is just not having a plan at all. And whether that's avoiding it or procrastinating, or you think it's for the ultra wealthy, Betsey, I'm going to turn it over to you, and let's talk through why people choose not to have a plan or to not address that. What do you see on that front?
Yeah, I think the biggest thing is people don't want to talk about it. It's just a topic where, you have to talk about it, but people really do avoid it. And I'll tell you that the reason that it's important to kind of get it done now is you never want to engage in estate planning when you're in the middle of a crisis situation. There has been countless times where I've been called to a hospital, a nursing home, somebody's in really rough shape and they realize, I've never had an estate plan done, or I really need to get things accomplished. And oftentimes it can be too late to do it at that time, because you do need to have capacity to sign estate planning documents. So the last thing you want to do is add to an already stressful situation by starting the process, when things are in the middle of a crisis. So I'd encourage everybody to, think about it now, where, you're clear-headed, you can kind of work through it. I will tell you that most people always come back after we're done, doing the estate plan, and they say that wasn't that bad. That was not as bad as I was thinking. That was, fairly straightforward. I do try to make it straightforward for people. It's now is really the time to do it when you're, able to, and have the time to devote to it. So I'm going to talk about kind of the three different groups of people that normally I see, because, really estate planning is for everyone. I think there's a misconception that it's only for people with, with estate, like very wealthy people with estates, but it's really a wide variety of people who can benefit from estate planning.
Yeah, I think one of the things that, one of the things that we see is a lot of times there's an event, right, where you're young and maybe you have kids and say, okay, what happens if something happens to us? Who's going to take care of the kids? Or what you were referring to is way later in life, you say, okay, I'm closer to death. I need to do something right now because it's inevitable. And there's a whole lot in between that gets missed. So what you're going to do is sort of jump into, you want to jump into the first one of?
Yeah, absolutely. So young families. Yeah. So a lot of times I see people, who are doing estate planning for the first time because they just had a baby, they have young kids. One of the few important things to do there would be in terms of your will, naming a guardian for any minor kids. It's really important to have that piece in place. And most people are aware of that. So that's often a trigger for starting the estate planning process. The other thing is, when you have a young family, many times then your beneficiaries are minors or younger individuals, maybe in their, early 20s, where you may not be comfortable with a kind of an estate plan where you just name young kids as outright beneficiaries of an IRA, life insurance policy, those sorts of assets. Usually young families would tend to do a trust-based package where you can be very specific about how you want your kids to receive assets from you. It gives you way greater control over asset distribution, where you can design it however you want to. You can provide for college. You can provide for a guardian for any minor kids. You can have early distributions for things like a down payment on a house. You can put requirements in there that they meet with a financial planner to go over, appropriate ways to invest or use money. So there's a lot of opportunities, a lot of planning opportunities for younger families, just because the beneficiaries are often young and you just want to make sure that they're protected. So that is kind of the first group of people that I see quite a bit, that it's important for them to have an estate plan.
Not that I want to go negative on this, but I think it's important. What happens if nothing's in place? You have a husband and wife, a 2 and a 4-year-old at home, and they both pass away. Can we get into what that would look like without something?
Yeah. So if you don't have a will or a trust or beneficiary designations, and even if you do have your kids on your accounts as a beneficiary, generally what happens is it goes through probate, which is that court process. It would end up passing to your kids. But if you have minor kids, that money would be put into a conservatorship account. So essentially, there would be a lot of oversight and investment from the court, but the entire amount would be turned over to them when they turned 18. And that's often a disaster situation, especially a lot of times with a younger family. One of their largest assets may be a term life insurance policy, where they get a large term life insurance policy. And most people wouldn't want their kids getting a large sum of money when they turned 18. So that's kind of what would happen if you didn't have this in place. When you have a trust in place, you would name like a trust as the beneficiary or the contingent beneficiary after a spouse. of a life insurance policy or an IRA. And then you spell out how you want the kids to receive assets, and you appoint who you want to be in charge of administering that. So there's not oversight by a probate court. It's somebody that you trust, that you want to invest and administer those assets for your kids. So that's how in practice it would happen if you didn't have that in place.
So you lose a lot of control. Hey, one other thing that I wanted to ask, because I don't want to exclude anybody. What if you're young and single? Do you not need an estate plan, or can you talk a little bit, maybe a couple of items? Yeah.
It depends on assets. So like you could be young, single, not have assets, but for example, college students, I've been doing a lot of those lately, and it's kind of on my mind because I have college age kids. Usually a power of attorney and a patient advocate for a college age student is a good idea. Because what happens is once you turn 18, your parents aren't able to make decisions for you. And if you were in a situation where you needed a medical decision to be made, that's where like the power of attorney, patient advocate designations would be important. If you're a young person and you own a house, it'd be important to engage in some estate planning so you have some control over what you would want to happen to that asset. And there are different options. And we'll go through some deeding options in the next mistake area. But yeah, it's going to be based on assets. And then also I think a power of attorney documents are always really important to have for someone.
Perfect. All right. So we'll jump into, I think, an often overlooked area that is empty nesters, right? Kind of this middle of life. And what are some areas that we want to look at if we're in that stage of life?
Sure. Yeah, absolutely. So a lot of times when I see somebody who's getting closer to retirement, oftentimes maybe they engaged in estate planning when their kids were little and their documents have been put in a drawer and haven't been looked at for 20 years. A lot of times then they're starting to look to see whether or not maybe their kids are able to serve in some of those fiduciary roles in their estate planning documents, in terms of like a successor trustee, their power of attorney. So it's kind of, maybe changing some ideas about how you want to handle that. And just making sure that your beneficiary designations and all of your assets are properly funded into your trust. So what happens, and estate planning is kind of a broad term for both the documents, but also making sure everything is tied together. So when I sit and do an estate plan with someone, I go through a to-do list that tells them how to go about making sure that you have proper beneficiary designations, everything is funded into your trust. But those are dealing with assets that you own at the time that we meet. Oftentimes after it's been 20 years, perhaps you've closed accounts, opened new accounts, you have a different house. So it's important at that stage too, where maybe it's been a while since you've done an estate plan, to make sure that all your assets are incorporated. So when I sit down with people who maybe did something a long time ago, we make sure we go through everything to make sure everything is properly titled and updated, because family situations and dynamics change over time. So we want to make sure that your estate planning documents reflect your current situation.
Yeah, that's perfect. Lots of change happening in that period of life. It's a great time, even if you have a plan, to revisit. And I think we're going to talk about that a little bit more, but that is an essential area. So now let's kind of transition to more later in life where, we can see some, this is very intuitive that you might need an estate plan later in life, but let's talk on these two areas, seniors and recently widowed, which there's some definitely areas that we want to take a fresh look at an estate plan.
Yeah, absolutely. So, I mean, this can be a vulnerable time. And it's really important. I mean, the power of attorney and the patient advocate documents, it's really important that you have those and you have those updated as a senior. I mean, there are times where somebody, perhaps has the capacity to make decisions for themselves, but perhaps they can't get out of the house or they're homebound in some way, and they need to make sure they have the appropriate person who's looking out for them, who's going to make good decisions for them, who's going to help them. You never want a situation where somebody is taken advantage of. So it's really important that those documents are all buttoned up. Thinking about long-term care is something that would be, it's another reason that, you want a power of attorney in place in case there needs to be applications filed for any benefits. Recently widowed too, making sure that, usually your spouse was on there as, the primary, fiduciary or beneficiary of accounts. So reviewing all that and, making sure that your successors are who you want to have as your successors. So those are all important. Again, reviewing funding to make sure that you have, the proper designations in place. In terms of your house, the deed to your house, how your assets are set up. So, and here timing is really important because again, and I talked about it earlier, you just want to make sure that this is done at a time where you have the capacity to really think through these and understand, what you're signing, who you're appointing, and that things are clear to you. So the timing is very important in terms of making sure that seniors are protected.
All right, perfect. So if that doesn't make the case that any stage of life, wherever you're at, don't make the mistake of not having an estate plan appropriate for your stage of life in place. All right. Mistake of incorrectly titling property. We talked about, what are the things when we were kind of preparing for this, what are areas that you often see? And this was right at the top of the list.
Yeah, this is a biggie. A lot of times I see that people are, and titling property really means deeds. You'll hear warranty deeds, quitclaim deeds, ladybird deeds. So titling property is how you own title to a piece of real estate. I find that this is an area where people often kind of engage in do-it-yourself type estate planning. But deeds have to be very precise, and there is a really large, room for error in drafting a deed. It has to be very precise. There are different ways of owning property. I would always recommend having an attorney draft a deed for you because it's harder to undo a deed. Once you add somebody, for example, as a co-owner to your property, they're on there, and if you want to get them off the property, they have to agree to be taken off the property. There can be many issues, liability issues. Oftentimes I see someone says, let's just add our kids on the title to our property so it can pass without going through probate. Which it could potentially pass without going through probate, but now you've had somebody else added to the title of your property that can end up being a disaster if they go through a divorce or a bankruptcy, or there's some issue, or they don't want to sell the property, or perhaps they do want to sell the property and you don't want to sell the property. So I would always avoid adding somebody as a current co-owner of the property. There are a couple of ways that you can avoid probate on real estate that I recommend. The first one that is pretty common, you've probably heard this term before, is a ladybird deed. So a ladybird deed is a quitclaim deed. The name ladybird is not going to appear in the deed itself. What it's referring to is language that states, I am transferring my property to myself for my lifetime. I have a life estate in my property. I retain the right to do whatever I want to with the property. I can sell it, gift it, mortgage it, lease it, do whatever I want to. But if I still own it upon my death, I want it to go to, and you can actually name beneficiaries right in the deed itself. You can either name individual people as beneficiaries, or you can name a trust as beneficiaries. You have to be careful adding individual people, and that's really kind of a case-by-case basis. I don't ever recommend somebody adds, 4 or 5 kids to a ladybird deed, because that can cause all kinds of issues with co-ownership in the future. But it is appropriate for some people to name, 1 or 2 individuals on a ladybird deed. A lot of people do, name their trust as the beneficiary. And I should also say that by doing this ladybird deed, if anybody has a potential Medicaid situation where they maybe need Medicaid to pay for nursing home care, having your property titled through this type of deed is allowable. So this is, the reason a lot of people do this. Another way to title property is just title it directly into your trust. And when you do it that way, you can have very specific language in the trust about what you want to happen to the property when you die. I see this situation sometimes in like a second marriage situation where perhaps you want to put language in there saying you want your surviving spouse to be able to live in the property for a certain amount of time. And then, who pays expenses. You can address all those things when you do it through a trust. And then you could state, after 5 years or 10 years or whatever you want, that the house then gets sold and divided between, perhaps children and a spouse. So the benefit of that is it avoids probate, and you can be very specific about how assets are real estate assets are dealt with. But you have to be very careful with titling, just because there are different ways of being co-owners. That's just something I always recommend that people, you have an attorney look over that or draft that for you, because that can create a lot of legal mess for somebody. So that's really the big thing, is just be really careful with titling property and deeds.
No, I think that's great advice. That's often one that when we're going through, people by default have to put a beneficiary on their IRA. They sometimes think through it on their bank accounts. But for a lot of people, a house is a major, if not the largest asset you own, and to not have that properly titled. Again, the whole, and maybe we'll spend a minute on this on the next slide. The whole goal of all of this is to have control and avoid probate. So while we're kind of transitioning to, other areas that people make mistakes, you want to talk a little bit about, like why we want to avoid probate, or can we dive into that?
Sure, yeah, absolutely. So when I say probate is like the probate court in the county that you live in. They are responsible for administering decedents' estates. When you have a situation where you don't have a trust or don't have beneficiaries, or there's some problem with your estate plan. So when you have to probate an estate, so an example would be, let's say you own a house, you don't have any, beneficiaries or a ladybird deed, it's not in a trust, and somebody dies. That house, even if you have a will, would have to go through the probate court to get to the beneficiaries of your will. The reason people don't want to do it that way is, first off, it's on public record, so it's out there for everybody to see. There's court oversight on it. There are a lot of different timing and filing deadlines. It can be expensive. Generally, you need to get an attorney involved, and it's just a delay. And so most people just want to keep the court out of their business, administer their estates privately with their, the beneficiaries and the interested parties in the estate. So that's why you'd want to avoid probate, because it can be nasty if it. I'm sure a lot of you have heard of nightmare probate situations. So that's why it's really cost, delay, and just having somebody else in your business would be why you want to avoid that.
No, that's perfect. And certainly if that's the goal, one of the reasons that in my experience in doing this, that I find clients who, we meet with them after the fact, or, we find out about an asset that they didn't tell us about before, is this area, this mistake right here I see often is failing to review and update your plan. And this is from all sorts of different things, right? Changes in the need, in just laws that have changed, your wishes, new accounts that you've opened. So we're going to do a deeper dive into all of these things of why it's important to update a plan. And then there was actually a question that chimed in about how is that done ongoing? How can changes be done every now and then as life changes happen? Are they amendments? Are they need an attorney?
Sure, yeah.
Can you touch on all that as we kind of talk through this big?
Yeah, absolutely. So any estate planning documents can be amended, revoked, changed over a period of time. So that's something that you would do with your attorney. Excuse me, I tickled. So in addition, Brandon, I'm going to just take a drink of water.
Take your time. Yeah, again, I'll fill in a little bit. I'll tell you some of the areas that I see often are new accounts. So you go and find a brand new CD or a money market at a different bank, and you quickly, maybe it's a husband and wife, wife goes in, opens the account, gets some money in there, and only opens it in her name. And then you forget about it. It's there. You don't really utilize it. Maybe you add some money to it and it builds up. And that's a perfect example. You now have an account in just an individual's name without any kind of beneficiaries or updates. So that's one example of why typically I think you recommend, Betsy, maybe every 3 to 5 years, at least take a fresh look. If you're not doing it right on the fly, take a fresh look. So I'll let you jump back in. Yeah.
Yeah. So any sort of major life event is a good time to take a look at your beneficiaries and your estate planning documents to make sure that, a marriage, a remarriage, a divorce, a birth of a child or a grandchild, change in a business ownership, all those are triggers to relook at things to make sure that your documents themselves reflect your current situation. But certainly, as Brandon said, with beneficiary designations, you just need to make sure that as you open new accounts that you're remembering oh, I need to put a beneficiary on there, or I have a trust. I need to make sure that that's, properly incorporated into everything. And then and making sure, another note that we have here is making sure that you're communicating, with any beneficiaries or family members or whoever your fiduciaries are, that these documents are updated and that the language is updated, where they're located. That's all really important to make sure that you're having that done. So I would definitely say every 5 years, it's important to take a look at it. And always, as you're opening new accounts, and a good resource is your financial advisor, your attorney. Make sure you're thinking about, bank accounts, like Brandon said, CDs, you can buy a new cottage, anything like that really needs to be addressed. And it may not be that the estate planning documents themselves need to be updated, but those assets need to be tied to the estate planning documents by either a beneficiary designation or retitling.
All right. No, that's perfect. So I think the takeaway from all of this is, just because you have at any period of time done an estate plan, it's an ongoing process. It's not just a transaction of drafting this document, putting it in place and feeling good. It's an ongoing process to make sure. And then updated language as well. And we're going to get into some other ones, but that's an area that you definitely want to make sure that you're not just assuming you did it once and it's all set. It will evolve and change, just like your life will evolve and change.
Yes, absolutely. Yep. And I always tell people too, to keep a really good ongoing list of assets with their estate planning documents, because when you look at like a trust, generally it does not list the assets you own in the trust. The language itself is going to discuss what you want to happen to whatever assets you happen to own upon your death. And so assets are incorporated into those documents by either retitling or a beneficiary designation. So you want someone to know, like, currently what your assets are. So I usually have people write them down so they would know who to contact, know what assets are included in the trust, and kind of keeping it together so somebody would have an easy time, rather than going through someone's mail or trying to access your email or online accounts, seeing exactly what you have in one spot. Perfect.
All right, let's dive into another mistake that I think some people just have this connotation of an estate is only there when you die. It's an estate that passes on to beneficiaries or, executors of an estate. Those are sort of the language that people have associated, but there's a whole lot more that an estate plan covers while you're still living. And let's touch on some of those and talk through how and why we might want some of those beyond just a will and a trust.
Okay, yeah, absolutely. So the power of attorney and the patient advocate designation are really the two main documents that are going to protect you in the case of a disability, or if you just need help, perhaps that, you are still able to make your own decisions, but you just need help getting out to the bank, maybe help filling out forms. So the two types of power of attorneys would be the financial power of attorney, which allows somebody to, for example, pay your bills, file your tax returns, assist you with Social Security, perhaps a Medicaid application, doing those sorts of tasks for you. You can nominate somebody during your lifetime to do that for you. There is a misconception that a power of attorney continues, once you're someone's power of attorney after they die, you can take care of things. That's not true. A power of attorney actually ends when somebody dies. So a power of attorney is someone who handles something for you during your lifetime. You can make changes to it at any time. You can amend, revoke the power of attorney. There's different types of power of attorneys. Oftentimes you still retain the right to make your own decisions. You're just adding somebody on there who also could help if they needed to. In addition, you're going to have the medical power of attorney, which is the healthcare or patient advocate designation. And that's the person that would be making medical decisions for you in case you were unable to make them for yourself. And that's the document where you can really get into what your specific wishes are regarding what type of medical care you want. And most of you might be familiar with these because, if you go into the hospital or go in for a procedure, they'll ask you, do you have a patient advocate or a medical directive? That's all included in one document called the patient advocate designation. So that's important to have. Again, both of these need to be executed when you have the capacity to sign documents, which is an important thing. So I wanted to explain kind of what would happen if you didn't have these documents in place and you didn't have the capacity to sign those. So there is a court proceeding included in this, in the probate court, as we're talking about, a guardianship and a conservatorship. So that's where you end up if you don't have these documents in place and are not able to sign them, where the court actually appoints somebody to make these decisions and do these tasks for you. So most people want to avoid doing that. It's a lot of extra paperwork. There can be fights, there's court oversight, and you're not really the one in charge of naming what you want and who you want to be in charge. So that's what happens when you don't have these documents in place. So yeah, and really nobody wants to be involved in a conservatorship or a guardianship proceeding. So it's really important that you think through who you would want to make these decisions. Do you want more than one person? Do you want co-power of attorneys? Do you want an individual power of attorney? And that's all really a specific case by case discussion that I have with my clients. I think it's important to understand, family dynamics, personalities, who's doing what now, to make sure you're making the right decisions about what fiduciaries you're naming in these roles.
What about how long are these good for? How often do we have to update them? And functionally, how do we
Sure.
communicate who's on these power of attorneys, right? And their responsibility.
Sure. So they're not something that go bad over time necessarily. But your wishes may change over time about who you want to name. So they don't expire after a period of time. But it's always good to still take a look at it, because who you want to name likely changes, or what your wishes are may change over a period of time. Once you've executed these documents, so for your patient advocate or your medical power of attorney, you're going to give a copy to your doctor. A lot of times they can scan them into whatever hospital system you're in. And so they just appear in your medical record. So that's something that is important to keep updated with your doctor, so they know who to look to make decisions if you were disabled, and obviously tell your patient advocate and give them a copy as well. The power of attorney document, I always tell my clients to make sure you're telling the people who you've named who your power of attorney is. That would come in, kind of as needed. So that would be if you need somebody to help you with Social Security, then you have to bring a copy of that power of attorney document with you. You don't need the original for it to be effective the way that it's generally drafted. So you can make copies of it. Different institutions can take a copy of it. But it's something that you can change, amend, or revoke at any time, as long as you have the capacity to do that.
A question that came in is requirements. Do you have to be 18? Is there any other
You do have to,
threshold?
you do have to be 18 to sign it. You have to have capacity to sign it. For a power of attorney in Michigan, you have to have 2 witnesses and a notary. There has to be an acknowledgement section on there. A patient advocate does not require a notary, but there's 2 witnesses on there. So there are some execution requirements involved. For a power of attorney for finances, if you need to file it with a court, there needs to be a 2.5-inch margin, and there's some kind of particulars about the document themselves. But that's how the execution of it works. So yeah, you do have to be 18.
All right. So just downloading it or writing on a piece of paper that this is my power of attorney is not going to fly with a financial institution.
Yeah, because a lot of the times who you're providing the power of attorney to would be a bank or a financial institution. And they're really picky about them. And so, they're going to send that to their legal department to take a look at, and they don't want the liability of accepting a document that's maybe, not your wishes or not done in the right way. So it has to be executed in the right manner. So, so it's accepted when your power of attorney goes to actually try to use it.
That's right. Okay. All right, perfect. So, all right, that I think in summary, don't wait until it's too late. This is something that has to be done, has to be reaffirmed, and have a dialogue with the people that you are asking to take on a pretty heavy responsibility, that they're really comfortable with what your wishes are and ready to enact that if and when that time comes.
Sure. And I'll also add that it is, it can be a burden for somebody to act as a power of attorney. A power of attorney can get paid for, usually I do an hourly rate for acting as somebody's power of attorney. So they shouldn't take on a financial burden, but it is time that not for a patient advocate, you can't get paid, but for a power of attorney, somebody can get compensated for their time in taking on those tasks.
All right. This is an interesting one as we were kind of coming up with the topics. And I think as just the world continues to move into more digital and online and in the cloud and, all of that, tech stuff that really impacts our day to day, ignoring that we live in a digital world and you have not only accounts, but a presence of who you are in a digital world. So let's maybe talk about that. And if you can kind of bring some real world stuff of what we could be doing on this, especially that password one, I thought that was really interesting.
Yeah.
So let's dive into the digital world. Yeah.
Sure. Yeah. So this is something that really has picked up in the past, 5 years. When I just started, practicing in this area 20 years ago, this was not a thing. Now, I mean, there's a couple of different issues that you end up seeing is, people have online accounts where, they're not getting statements in the mail. Everything is either going through email or accessing via passwords. It's really difficult if somebody becomes disabled or upon their death to figure out what they have. So just letting somebody know what online accounts you have is great. But accounts like, Bitcoin and crypto and some of these newer accounts like that, those need to be incorporated into your estate plan by either a beneficiary designation or retitling. And whether or not you can do that with those accounts is kind of going to be a company by company thing. This is like a really quickly evolving, area of practice. And you've probably even seen like some nightmare situations where somebody can't remember whatever their password is to, their crypto account. And if they enter it one more time, they're going to lose access to it. So it's really important to communicate all these things to any of your loved ones or whoever you want to administer these things, because they wouldn't know about it unless you tell them about it and tell them how they could access it. A really big one is also like the password to your iPhone. I think some people think you could just, if you can't find it, you could contact Apple and they would be able to crack your password. That's not the case. They aren't able to. They could wipe your phone clean, but they're not going to be able to access a loved one's phone. I've had a couple of really sad situations recently where somebody, like a young person, died and, their whole life is on their phone and their parents not able to access it. They wanted to get some pictures off there. They wanted to get some contacts off there. There are certain ways to access it via the cloud if things are uploaded there, but phone passwords would be a big thing too. And, if you want to keep it private and not share it with anybody now, I totally get that, but it should be written down somewhere so somebody is able to access that. The other thing I always put in my trust documents too is language that allows the trustee to access digital assets and social media accounts, because there are times you need to be able to shut those down if somebody passes away. And so that's something that you can give your power of attorney or your trustee the authority to do. So this is like a very quickly evolving area that I think will continue to evolve. We hear about, Chat GPT and some of the, just how fast things are changing. So it's something to keep an eye on, and more people are having, online or, digital assets that we just need to make sure that we're thinking about those when we're going through our estate plan and talking about how to properly fund your trust or have those assets incorporated into your plan.
No, that's good stuff. So lots to think about on all of these things. And, that's an area that is only going to get more and more important and going to be more prevalent in everyone's lives. So to have that be part of your overall plan and not forget those things is incredibly important. So, as a recap, we've got a couple more questions that popped in that I'm going to sort of rapid fire. We're getting closer to our, planned content time. But if anybody else has additional questions, wants to chime in with those, we'll try to take those as we go for the next maybe 5 or 10 minutes, depending on how long the questions are and where the question goes. But one of the ones that came up, and I hear this often, and maybe you can just have a general discussion around the difference between adding, and I know you touched on it a little bit, but adding the actual owners, right? Like a daughter or son to a bank account or a house versus other means of like a transfer on death or other more, ideas that help protect and out without giving actual ownership. Can you maybe talk on pros and cons of
Sure.
that?
I mean, yeah, absolutely. So it's not uncommon for somebody to occasionally add a child to a bank account in order to pay bills, and have access to it that way. It's not the recommended way of doing it. I mean, it many times it works out fine, but what can happen is, especially if there's multiple siblings involved and you have maybe one person on the bank account, I certainly have seen times where all of a sudden, where did that money go? Or people questioning, well, what, so-and-so had access to this money. What about the rest of us? What happens is if there's a joint account and you add one child to it and you die, that account becomes completely the asset of whoever is left on the account. So even if you have other kids, that you intend for those assets to go to. I mean, hopefully everybody plays nice and shares those, but there's not really a requirement that they do that. So I think the better way of doing it is to put a power of attorney on the account so someone can access it during your lifetime if you were disabled or needed help. And then doing something called a transfer on death designation, which is essentially a beneficiary designation for a bank account. So that's really the recommended way. I mean, I understand that it's pretty common to add somebody to a bank account for convenience, but as an attorney, I see like the bad side of that when, someone takes the money or is not, using it as their own account, and that's hard. That's a hard situation. So there's better ways of doing it, but you do need to make sure you're thinking about bank accounts. Sometimes people forget about the fact that, they might have the beneficiaries on their IRAs and their life insurance, but they forget about the fact that they have a bank account. And if you have a power of attorney on a bank account, that person is not entitled to your assets when you die. So you still need to make sure you always have that transfer on death designation.
Yeah. No, I think one thing that, as you were saying, stood out to me is, we'd all like to think that estates are settled without any conflict but it's just not the case. Money can change people's just mindset, and you never know if they're in a tough situation and then take advantage of that. So to have it properly documented and not, we want to give everybody the benefit of the doubt, but that's not always how life works out. So control as much as you can.
Absolutely. And you want to set up your family for not having conflict upon your death, even if somebody didn't do anything wrong. You just want to kind of, keep things smooth so you don't want your kids fighting amongst each other.
No, that's exactly right. Yep. It's a time to grieve, not to fight over stuff and go through probate and all that.
Absolutely.
So we work with a lot of business owner clients, and I had a couple of questions that kind of come in, but one that I think would be good to jump into is if you own a business, let's say it's an S Corp or an LLC or, this person specifically asked if you're a married couple, but maybe just the business is, the one individual is an owner.
Yep.
Can we unpack that a little bit? Could probably be a whole webinar on its own, but
I mean, generally,
incorporate.
Yes. I mean, generally you're going to have, operating agreements or buy-sell agreements, depending on what, type of business you have that address, kind of the disposition of that business. But for example, like if you have an LLC, the shares of your LLC should be either transferred into your trust or transferred into your trust upon death. So you appoint somebody would be your trustee who would be able to close out that business, make transfers, and then you can be specific about what you want to happen to any business assets. I mean, there are some businesses where the value is you and that person, and maybe it doesn't have value beyond that. But if you have assets where you have, assets that you need to sell or need to sell a business or pass it on, you need to make sure that that's coordinated into your estate plan. If you have for example, a bank account and it's in the name of an LLC, your spouse wouldn't be able to go in and access that bank account because it's a business account. So when you can transfer that into a trust, usually a business owner always really does need a trust. You can appoint somebody to go in to wind up that business and access those accounts and what needs to be done. So you should certainly have a plan in place if you are a business owner.
Now, what about power of attorneys? Can a power of attorney have authority to make business decisions, or is that separate, or does it need to be outlined?
So I do put that in my power of attorney document. A lot of times I do a separate one because sometimes there's different people that you'd want to handle business decisions versus personal decisions. That's a sticky one though, in terms of a bank, what they're accepting, because business accounts are treated different and banks get very nervous about those. So, I mean, it's better to have, to make sure that it's funded into your trust so that person can take care of it, but you need to do something because leaving it alone, you're not going to be able to access those accounts or assets upon someone's death or disability. But you should certainly have an overall plan about what you want to happen to the business. If you want it to be sold versus transferred to another family member, all those things should be addressed.
All right. I think we got time for one more, and this comes up often, is about contesting a trust or saying, no, that's not what mom's wishes were. She wanted me to have it. Can we talk a little bit about how that plays out and maybe language that's important to have in a
absolutely. So that's going to be, probate litigation, essentially, if you are, given a copy of a trust and you think there's some problem with it. The two most common reasons somebody would contest a trust would be based on, the person who's signing it didn't have capacity, that they, perhaps had dementia, were taken advantage of, made changes close to the time of death, maybe and didn't understand what they were doing. The other one would be undue influence, which is where, maybe somebody is an elderly person who maybe is struggling with some capacity issues, and you have somebody who's, a primary caregiver, or somebody who is maybe taking advantage of the situation or coming in and trying to kind of get them to make some changes. So those are the two biggest reasons somebody challenges a trust. Those are long, really emotional, expensive, propositions. So that's a tough scenario. A lot of them may end in like a mediation type situation, but that's usually why somebody challenges a trust. So I always want to be really careful when I am executing estate planning documents, and you have to be very clear who your client is, and that you're taking direction from the client themselves and not a third party who's calling you saying, mom wants to make these changes. Like, everybody needs to be on the same page, and be very careful about making changes when you have any questions about something that might be going on. But those are tough situations but that does end up in the probate court, and it can take sometimes years to resolve.
Yeah, no, one of the things we recommend is just having an open and honest dialogue with parents and or kids. And, we can help facilitate some of those discussions. The more, you don't even have to get into dollar amounts, but wishes and the general spirit of what your plan is going to entail. It's much better that have that conversation while you're living, and to say I have this in place and it's in writing versus it being interpreted after the fact and when everyone's emotions are high.
Absolutely. Yeah.
All right. I think we covered a lot. 45 minutes of estate planning a talk is probably at everybody's limit, but what we're going to do is we're going to break down this webinar into some small little thoughts, and we'll continue to get those out in little chunks, as they might be more relevant. And then, if there's ever an area that you want to dig into, certainly, our firm can help point you in the right direction or talk through or do some reviews. If you need some estate planning work done, Betsey, you want to just take 2 minutes to give a quick plug of how you work and how you operate and how people can?
Yeah, sure. Yeah. So I'm always, I work in Metro Detroit and all, 3 counties around here. Basically, I always do free consultations for people if they have existing documents they want to go over and review to kind of see where things are at. Or if people want to start from scratch, I try to make the process as streamlined and straightforward as possible. But usually it involves 2 meetings. Usually it's, maybe a month start to finish to get everything done. Once estate planning is done, that's when we work to make sure the trust is funded and everything is kind of buttoned up. And, I would work with Brandon to make sure everything is titled properly. So that's, in terms of process, kind of the way that I work. But yeah, I'm happy to answer any questions or help anybody that needs help with it. All
right. Excellent. So yeah, I think to wrap up, I'll always encourage, in the next 48 hours, if you learned something from this, take an action on it. If you don't, I promise 48 hours pass and you'll be in the summer and you won't do anything with it. And let's not wait till it's too late. So if you don't have a plan, reach out and start the process to at least investigate what that would look like. If you have some moving parts or maybe some changes or something here resonated and you want to take a fresh look at it, send a quick email or kind of figure out, all right, how can I get this in motion and take some action on getting, some reviews or some updates done. So Betsey, thank you so much for your time, your expertise and insights. We appreciate it today. Thanks everybody for attending, and look forward to seeing you on the next workshop. Thanks so much.
Okay. Have a good day.
Bye-bye.